Hello and a very warm welcome to everyone. We welcome you once again to Vestralex free online community classes on law. This is a free legal literacy initiative for you, by you, and possible only through the generous contribution of our seniors, mentors, guides from across India. And here we discuss very unique topics of law simply because it's our privilege to have the interaction with our seniors about what are the varied aspects to truly explore law. So, in light of that, we have one of our very dearest mentors and guides, Shri Asim Pandya sir. He's a senior advocate practicing at the Gujarat High Court. He's the former president of the Gujarat High Court Advocates Association. He's the founding partner at Asim Pandya Associates. He's author of various books, including Writs and Constitutional Remedies, Law of Contempt of Court, Law of Bail, Rights of the Arrested Person, Investigation and Bail, Excise Law Procedures. So, and Sir writes a lot of articles and all. So again, all of these things are available online. At the same time, Sir is a hobbyist. He got a bronze medal in the Ahmedabad badminton tournament. He participated in All India Veteran Badminton Tournament in Goa in 2021. He plays the tabla, keyboard, and is fond of Indian classical music. Direct his music direction in Gujarat Anthem is appreciated by all. He has directed music in Namu Tane Hun Gurjari.
Namu Tane Hu Gurjari. Namu Tane means Namaskar. I bow down to the land Gurjari. Gurjari means Gujarat. I
So,
bow down to it. So
so I
Namu
bow
Tane Hu
down to the
Gurjari.
land of Gujarat and I bow down to the land of India. And sir, भारत माता की जय, जय माता दी. And sir, इतनी अच्छी ये सर आपने एक इतनी खूबसूरत बात भी आज कही हमें कि हम हिंदी में भी इस पे बात करेंगे कि टॉपिक सर आपने इतना यूनिक चूज किया है. So I request you to kindly take it forward and we very warmly welcome you.
Okay. So thank you very much, Keshav, for a very nice introduction. Uh, Namaskar and good afternoon to everyone. As Keshav said, I would be speaking partly in Hindi, partly in English, because those persons who are unable to understand Hindi must also understand from English. So I will use both the languages because the topic is such that I cannot confine this webinar to English language only. The topic is very important: possibility of permitting regional languages in the High Court proceedings. A very important but little bit controversial subject, because the legal fraternity and mostly those who are practicing in High Court or the Supreme Court of India are not unanimous on this issue. So we will find there are diverse of opinion on this issue. So, but the subordinate courts lawyer are keen to have High Court proceedings to be conducted in the regional language. So, the subordinate judiciary and subordinate court lawyers are all with us in this movement which we are spreading right now. The topic we will have to start from the aspect of the pre-constitutional provisions, and then we will move on to constitutional provisions. What is the global perspective on this issue? How many countries allow more than two languages in federal court or superior courts? तो सुपीरियर कोर्ट में कई सारे कंट्रीज है जिसमें एक से ज़्यादा भाषा का प्रयोग किया जाता है और वो अनुमति देते हैं उसकी, तो वो भी बात करेंगे. और जो कॉन्स्टिट्यूशनल प्रोविजंस है, मेनली पार्ट 17 of the Constitution of India which provides for language, so उसके बारे में भी बात करेंगे. और बहुत इम्पोर्टेंट बात है जो सुप्रीम कोर्ट ने 1965 में एक डिसीजन लिया कि भाई अगर कोई भी कोर्ट में, हाई कोर्ट में या सुप्रीम कोर्ट में कोई अलावा हिंदी इंग्लिश के अलावा कोई भी लैंग्वेज का अगर उपयोग करना है, so Supreme Court's view will have to be taken into account. That kind of provision is also made now. But before that, let me start with the aspect that how did English become the official language of India? You all of have heard about Lord Macaulay. His full name was Thomas Babington Macaulay. He introduced English as an official language in India in 1835. During British rule, he was in need of Indian servants who could serve the British government. So not only he introduced English as an official language of our nation in 1835, he also passed a law which is known as the Education Act, Higher Education Act 1835. So English Higher Education Act, the name is the English Higher Education Act 1835. So that is how we have been acquainted with using English language for official purposes throughout the nation. And even after independence, today almost 77 years have passed. Still, the English language is the only language which is permissible to be used in Supreme Court of India and almost all high courts, barring 4 high courts, which I will advert to little later. तो सुप्रीम कोर्ट में और सब हाई कोर्ट्स में अभी भी हमारे इंडिपेंडेंस के 77 ईयर्स पास होने के बाद भी ओनली ऑप्शन इज़ इंग्लिश लैंग्वेज. 4 हाई कोर्ट्स है जिसमें हिंदी में बात कर सकते हैं, हिंदी में बहस हो सकती है, हिंदी में प्लीडिंग्स हो सकते हैं. तो वो कैसे हुआ और अभी क्यों नहीं हो रहा है? इट इज़ ए मैटर ऑफ ग्रेट कंसर्न फॉर ऑल ऑफ अस कि भाई 4 राज्य में ऐसा क्यों हुआ और बाकी के राज्य में अभी भी वाई इट इज़ नॉट परमिसिबल टू मेक सबमिशंस इन द रीजनल लैंग्वेज. If we talk about the preamble of the Constitution of India, it gives liberty of thought and expression. Article 19 guarantees fundamental right of freedom of speech and expression. Now, these rights which are guaranteed, if they are guaranteed in such a way that we cannot speak our own mother tongue in high court proceedings, then there are no rights. So freedom of speech and expression must include within its sweep the freedom to express effectively. अब इफेक्टिवली हम कैसे बोल सकेंगे अगर हमको मना किया जाए कि नहीं, आपको आपकी भाषा में बात नहीं करनी है, आपको सिर्फ इंग्लिश में ही आर्ग्यूमेंट्स करनी है, तो उसमें मेजॉरिटी पर्सन्स people of India are excluded from understanding the judicial proceedings, nature of judicial proceedings, what is happening in the court. कोर्ट में क्या हो रहा है वो लिटिगेंट को मालूम ही नहीं है. आप सोचेंगे तो पूरी जो जुडिशियल सिस्टम है वो लिटिगेंट्स के लिए है, वो जजेस और हमारे लिए नहीं बनी है. तो अगर वो लिटिगेंट के लिए है तो लिटिगेंट को समझ में आए इस भाषा में कोर्ट की प्रोसीडिंग्स होनी चाहिए, वो मैं मानता हूँ और मैं उसका वो स्प्रेड भी कर रहा हूँ कि भाई ये होना चाहिए, क्योंकि फ्रीडम ऑफ एक्सप्रेशन विदाउट परमिटिंग द पर्सन टू स्पीक इन मदर टंग इज़ नो फ्रीडम एट ऑल. तो अगर प्रीएम्बल की बात करते हैं तो एक तरफ हमारे पास ये बोला है कि लिबर्टी ऑफ थॉट एंड एक्सप्रेशन, फंडामेंटल राइट की बात करते हैं तो फ्रीडम ऑफ स्पीच एंड एक्सप्रेशन इज़ देयर. ऑन द अदर हैंड, नाउ आई विल ड्रॉ योर अटेंशन to the most crucial part of the Constitution of India, that is Part 17. Part 17 of the Constitution of India, which starts from Article 343 and which ends at Article 351. So Part 17 consists of 4 chapters. उसमें 4 उसमें चैप्टर है. पहला चैप्टर है लैंग्वेज ऑफ द यूनियन ऑफ इंडिया, तो यूनियन की क्या भाषा होगी. दूसरा जो चैप्टर है वो है कि हर एक स्टेट की क्या लैंग्वेज होगी और एक स्टेट दूसरे स्टेट से कौन सी भाषा में व्यवहार करेगा और एक स्टेट सेंट्रल गवर्नमेंट के साथ कौन सी भाषा में पत्र व्यवहार करेगा. तीसरा चैप्टर है, वो है द लैंग्वेज ऑफ द सुप्रीम कोर्ट ऑफ इंडिया एंड हाई कोर्ट ऑफ इंडिया, हाई कोर्ट्स, रिस्पेक्टिव हाई कोर्ट। तो वो तीसरा चैप्टर है। एंड चौथा चैप्टर है, दैट इज डायरेक्टिव्स विच आर गिवन अंडर द कॉन्स्टिट्यूशन टू स्प्रेड द नॉलेज ऑफ हिंदी। तो हम पहले बात करेंगे आर्टिकल 343 की। वो कह रहा है कि भी हिंदी इन देवनागरी स्क्रिप्ट is the language of official language of India Union. We have no national language. Please mind it. We have no national language. It is considered to be an official language. ये बात शुरू करने से पहले मैं एक कैवियट भी रखना चाहता हूँ आप सबके सामने कि दिस वेबिनार इज नॉट अगेंस्ट इंग्लिश लैंग्वेज. Every language has its peculiarity, it has its own beauty. हमारी जो बात है ये इंग्लिश के अगेंस्ट में नहीं है. हम ये कह रहे हैं कि इन एडिशन टू इंग्लिश देयर हैज़ टू बी एन अपॉर्चुनिटी टू आर्ग्यू, मेक सबमिशंस इन द रीजनल लैंग्वेज. अदरवाइज जो हमारी जुडिशियल सिस्टम है उसका कोई मतलब नहीं रहता है. तो ये कैवियट हम याद रखेंगे कि भी इट शुड नॉट बी कंसिडर्ड दैट वी आर अगेंस्ट द इंग्लिश लैंग्वेज. नो, इंग्लिश लैंग्वेज इज़ वेरी गुड लैंग्वेज, बट वी आर सेइंग दैट regional language plays very important role. Now, if we talk about the mother tongue, why everyone is giving importance to a mother tongue? All over world, all psychologists are unanimous almost that primary education of a child should be in his mother tongue. The reason behind is that child does not have to learn that language. It is by process that family speaks that particular language, mother speaks that language, and that is how it is known as mother tongue. So the child has a capacity to express himself in a best way, best possible manner in mother tongue. Now when child is deprived of this facility of speaking in its mother tongue, his capability of thinking is substantially inhibited. सीधा असर उसके बेसिकली बिकॉज उसके पास वोकेबलरी नहीं है. सपोज आई एम ए गुजराती पर्सन, माई मदर स्पीक्स गुजराती, माई फादर स्पीक्स गुजराती, फैमिली स्पीक्स गुजराती. तो मुझे गुजराती बोलने में कोई दिक्कत नहीं है. मैं सबसे अच्छा ज़्यादा एक्सप्रेस अपने आप को गुजराती लैंग्वेज में कर सकता हूँ. हिंदी बीइंग ऑफिशियल लैंग्वेज एंड वी आर यूज्ड टू वॉच हिंदी सिनेमाज अ लॉट, तो वो भी हमारे इसमें आ गई है ब्लड में कि भाई ठीक है हिंदी भी हम बोल सकते हैं. अदरवाइज इफ़ यू सी माई फॉर्मल एजुकेशन, हिंदी इज़ ओनली वन ऑफ द सब्जेक्ट्स लाइक इंग्लिश. सो एंटायर ट्रेनिंग इज़ इन गुजराती, माई एंटायर ट्रेनिंग इज़ इन गुजराती. तो अगर मुझे इंग्लिश में बोलना कहा जाएगा इन द चाइल्डहुड, I will not be able to express myself for two reasons. First of all, I do not have that sufficient vocabulary to convey my thoughts and feelings to somebody else. Secondly, my expression power is inhibited because I do not know how to construct a sentence. तो मैंने ये देखा है कि those who have studied their primary education in their mother tongue, their logical faculty is very good. If you examine the persons who have succeeded, who are leaders of nation like Mahatma Gandhi, Sardar Vallabhbhai Patel, so all of them have studied their primary education in their own mother tongue, and that is how they can express themselves and they could become a very good leader. So this is the importance of the mother tongue in the life of everyone, and therefore it is most crucial that when it comes to a judicial system, every person should be permitted to speak in the regional language which he knows by his birth. मैंने आपको ये भी बोला कि ये सिस्टम लिटिगेंट के लिए बनी हुई है. अगर आप हाई कोर्ट या सुप्रीम कोर्ट की बात करेंगे, that litigant is sitting in the court, he is unable to understand what is happening in the court, what arguments are being made by his advocate, what queries are put by the judge concerned to the advocate, whether his lawyer was ready with the matter, whether he is speaking the same thing what was briefed by him in his mother tongue or regional language. So he is absolutely in dark what is happening in the court proceedings, though the system is meant for it. Therefore, it is all the more necessary that in every regional high court, in every state, in addition to English, there has to be a facility for providing an opportunity to the lawyers to speak in his regional language. So I was on Article 343, which says that the official language of the union would be Hindi in Devanagari script. But since we have suddenly become independent in the year 1947 after British rule of about more than 150 years, the constitutional makers made it clear that for first 15 years, English should continue as the official language of the nation. And there should not be any tampering with it because it's a transitional period. And in the transitional period, one should not try to deviate from what is transferred to us by the British government. So nobody was allowed to tamper with English language for the first 15 years. Only option is given to the President of India to issue an order permitting Hindi as an additional language in addition to the English language, if he chooses. But that has to be done by an official order to be issued by the President of India. Article 343 further says that even after 15 years, if the transition period is not sufficient enough to develop Hindi language fully, or if we are not in a position to substitute the entire legal system in Hindi language, then English can continue to govern the communications between the union, and it would be the official language of the union even after 15 years. So that is the scope of Article 343. Now, there are two most important articles because this discussion ultimately turns on it. Article 344 is very important, which provides for constitution or formation of a language commission. The language commission was given task to give recommendation to the president that what kind of language the union should speak and what kind of language should be permitted in every state. So Article 344 provides for formation of language commission at the end of 5 years of the independence. When the constitution came into force on 26th January 1950. So 5 years. So before 1955, first language commission was to be constituted. And the second language commission was to be constituted at the end of 10 years. So by 1960, two language commissions were to be constituted, and that language commission should consist of whom? The language commission should consist of the chairman and the members who are to be selected from the languages that are included in Schedule 8. One may have to refer to Schedule 8. When Constitution was made, there were only 14 languages in the Schedule 8. It has nothing to do with any that languages included in Schedule 8 are the official languages. It only speaks that if the language commission is to be constituted, then chairman and the member should be taken from those persons whose the languages who are mentioned in Schedule 8. So 14 languages were there. originally. बाद में I think there are 8 languages included. So today, Schedule 8 consists of 22 languages. तो पहले तो 4 लैंग्वेजेस इंक्लूड हुई और बाद में 4 लैंग्वेजेस इंक्लूड हुई. तो टोटली अभी शेड्यूल 8 कंसिस्ट ऑफ 22 लैंग्वेजेस. Now, so far as first language commission is concerned, it was constituted in the year 1955. It was presided over by Mr. Bal Gangadhar Khair, who was the chairman of that first language commission. He submitted his report in 1956. This report is very important because it provides that in High Court proceedings, in addition to English language, the regional language should be permitted to be used. So that is a clear recommendation of the Language Commission. Article 344 also contemplates, because Language Commission is contemplated only twice. First, at the end, before the end of 5 years, and second is before the end of 10 years. Thereafter, it's all. Then there is a provision for constituting a language committee who would examine the report of the Language Commission. And after examining the report of the Language Commission, the Language Committee will also give its opinion to the President of India about what should be the language of Union, what should be the language of the state, and what should be the language of Supreme Court and High Court in particular. So if you examine the language committees that are constituted from time to time, because language committees are to be constituted from amongst the members of parliament. So 20 members are to be selected from the members of parliament, and 10 members are to be selected from the state councils by the member of parliament and state council. So that is how 30-member committee, language committee is always there, which keeps on giving recommendations to the President of India about the languages to be used by the states and the Union of India. So if you examine those committees' reports also or recommendation, they have also stated that in every High Court there has to be a facility and there has to be an option to speak in the regional language. So Constitution, please mark this important aspect, because many things turns on the later discussion. The Constitution contemplates only Language Commission and Language Committee in the matter of permitting a particular language to be used in court proceedings. Supreme Court or High Courts have no say in the matter which language is to be used in a particular High Court or a Supreme Court of India, because judges are not experts. I am also not an expert. Only those people who are dealing with the languages, they can recommend that what is an ideal language for the Union of India or what is an ideal language for a particular state. Do you think that judges are expert in this field? No. And therefore, constitutional framers deliberately kept High Court and Supreme Court away from the aspect of this use of a particular language in Supreme Court of India or the High Courts, regional High Courts. So these are the only two authorities which can give certain input with regard to the languages. Now there are 4 states which I would like to point out where Hindi language is permitted. First is state of Rajasthan. Even prior to the Constitution in 1949, Rajasthan High Court Ordinance 1949 section 47 clearly permitted that the language of Rajasthan High Court would be Hindi Devanagari script, and it went to the extent that even judgments, decree and orders are to be delivered in Hindi. So that was the ordinance in 1949. But later on, because the Constitution came into force and Article 348 has come into force, which has clearly stated Now we go to Article 348. We have discussed about 344, which provides for language commission and language committee. Now 348, which is very crucial for our discussion. 348 provides that the language of the Supreme Court and High Court shall be English unless a contrary law is made by Parliament. So Parliament is given free hand to make a particular law permitting or substituting English by Hindi or allowing Hindi as an additional language in Supreme Court of India. And so far as states are concerned, English and Hindi or any regional language can be permitted by Parliament by making a law. Now how does Parliament make law? Even Parliament is not that expert that which language should there. Therefore, Parliament has to take advice of the Language Commission and the Language Committee. On that basis, it will be in a position to form an opinion that yes, the time is now right either to substitute English with Hindi or it should be allowed as an additional language in Supreme Court of India, and in addition to English, whether regional language should be permitted in a particular high court or not. So that is left to the Parliament. The second option, which is also there in Article 348 sub Article 2, which is most crucial because these four high courts where Hindi is permitted is because of the exercise of power under Article 348 sub Article 2 of the Constitution of India. Article 348 sub Article 2 of the Constitution of India provides that the governor of the state, with the previous consent of the President of India, authorize use of Hindi or a regional language in High Court proceedings. This is a very important provision, whether Parliament makes a law or not, but if the governor, in aid of the Council of Ministers, on the basis of the decision of the State Assembly, if he is of the opinion that in a particular High Court, a regional language should be permitted in addition to English language, then he is entitled to issue authorization. So in Rajasthan, the governor has already issued in 1950 and it has continued. So in Rajasthan, the arguments are permitted in Hindi, pleadings are also permitted in Hindi. Similarly, I think in 1969, UP is also permitted to use Hindi as an additional language. We are not talking about substituting English. English may remain as a common language, but the lawyers, large majority of lawyers who have studied in their vernacular languages, should be able to participate in the High Court proceeding and Supreme Court proceedings, and they should be able to argue cases in High Court, in their particular respective High Court and the Supreme Court of India. So Uttar Pradesh 1969-71, Madhya Pradesh is also permitted to use Hindi language in addition to English, and Bihar in 1972. So these are the states that are allowed to these states permit use of Hindi in addition to English. Now, why this kind of discrimination so far as other states are concerned? Now, very interesting aspect I will now focus, which is very important and which you must keep it in mind, that in the month of March 1965, there was All India Chief Justices Conference. In Chief Justices Conference, all the Chief Justices of different High Courts and CJI were present. They took upon themselves the task that whether a particular language should be allowed to be used in a High Court or not, and whether Hindi should be permitted to be used in Supreme Court of India or not. So they unanimously took a decision that though Constitution does not contemplate our consultation in the matter of the language to be used, we request the central government that whenever the question arises as to whether Hindi should be allowed to be used in addition or in substitution of English, or whether a regional language in High Court should be permitted to be used in addition to English. We should be consulted in this matter. So they passed a resolution on 26th March 1965. Now, very interestingly, they did not release this resolution to the press. So media was kept in dark. Why this was done? It is a matter of inference. If that had been released to the press in 1965, probably it would have led to various agitation all over India. So this aspect was kept secret so that people do not come to know about what has happened. Otherwise, if this had been released in the year 1965, this resolution that Supreme Court should be consulted in the matter of language to be used in High Court and Supreme Court, and they will have a say in the matter of language, then in all probabilities, all states and all lawyers would have come out with agitation at all India level. So deliberately it was not circulated to the press. It was only sent to the Prime Minister, Home Minister and the Minister of Law. In 1965, once this resolution was placed before these three authorities, they constituted one committee. And that committee was asked to decide what is to be done. Now that committee surreptitiously accepted the resolution of the Chief Justice's conference. So though Constitution does not contemplate the role of the Supreme Court of India or High Court in the matter of the language to be used, by backdoor entry, in surreptitious manner, suddenly Supreme Court is given some say in the matter. Now, interestingly, even that resolution also states that unless Hindi becomes ripe enough to substitute English, it should not be allowed to be used. Now, who were they to say in 1965 that Hindi was not rich enough in 1965 to substitute English? For the timing, I am not on substitution. I am simply focusing that everyone should have an opportunity to speak in his mother tongue or regional language in High Court proceedings. And if you are appearing in Supreme Court, there has to be two languages like Hindi and English. So they opined that Hindi is not ripe enough to substitute or to be permitted as an additional language, bypassing the weighty recommendations of the Language Commission and the language committees, because language committees have clearly opined that yes, there should not be any harm in permitting a person to speak in his regional language in High Court proceedings and Hindi in Supreme Court of India. So this is how the power which are not there has been arrogated by the Supreme Court of India in 1965. But be that as it may, even after 1965, 1969 and 1971 and 72, three states have been allowed Hindi language. Now I will give few dates that in 1997, West Bengal, Governor of West Bengal gave authorization for using Bengali in Calcutta High Court. Now, in 1997, their proposal was rejected or disapproved. Now, who is Supreme Court to disapprove? They have been just given consultative role. They can say that, okay, we think that it is desirable or not desirable. They cannot sit on the proposal which is backed by the decision of the State Assembly, Council of Ministers, and duly authorized by the governor, because in democracy the people's wish is paramount. So whatever people wish has to be given priority and that has to be followed, except when the people wish is contrary to the basic structure doctrine. Barring that, there are no limitation. We are a democratic country, and nobody can stop people's wish to be implemented. So 1997, the first proposal of West Bengal was turned down with a cryptic resolution of the Supreme Court, full court, that hereby do not approve that proposal. So after full deliberation, after due deliberation in the full court, we did not approve this proposal. Now what kind of deliberation has taken place, we don't know. It is not forming part of the minutes. It should form part of the minutes, because if such a order, judicial order is passed that upon consideration of the facts and circumstances of the case, I do not agree with the judgment of the trial court, the High Court or Supreme Court would quash and set aside the order on the ground that it lacks reasons. So though the resolution of Supreme Court of India is not backed by any reason, it simply said upon deliberation in full court, the Supreme Court is of the view that the proposal deserves to be rejected. Now thereafter also, since the law contemplates that authorization has to go to President of India, how can mere say of the Supreme Court would completely set at naught the democratically taken decision by the state? So in 1997 this has happened. In 1999 again on 7th May, on 15th December 1999, again proposal was sent for consideration of the Supreme Court, and on 7th May 1997, similarly, that since earlier in 1997 this kind of decision has been taken, we do not approve it. Then in 2012, proposal from Chhattisgarh, Madras and Gujarat to permit Hindi, Tamil and Gujarati were made by the governor concerned. But again in Supreme Court, without giving reason, in their full court meeting, relying on their decision of 1997, which is cryptic, which is unreasoned, the decision of 1999, which is again cryptic, which is not backed by reasons, has simply disapproved the proposals of these three states, where governor said that state assembly has passed a resolution that Gujarati should be allowed to be used in High Court proceeding. Council of Ministers has also given an opinion to the governor, and governor, before he gets a consent from the President of India, as per the convention which was evolved in 1965, send it to the Supreme Court. And thereafter what has happened to this proposal, we don't know. In fact, in my personal view, once this Supreme Court gives an opinion that they are not approving this proposal, still the proposal has to go to President of India, because governor with previous consent of the President can authorize. So consent is hampered by the Supreme Court's decision. It ought to have gone to the President of India. President of India ought to have considered that view, because they have said that we are of the view or we are not in favor of that view. And President of India can even bypass that resolution of the Supreme Court of India. Under the Constitution, Supreme Court is, President is not bound by the decision of the Supreme Court, because unlike Article 217, there is no requirement of consultation in the matter of which language is to be used. So, Supreme Court has completely set at naught this democratically taken decision even in 2012. One more attempt was made in 2014 by Tamil Nadu Bar, and Tamil Nadu government also in 2014 again sent a proposal, authorization to Supreme Court of India, and Supreme Court of India has not approved it. So today the fact remains that 4 states here are using Hindi language. Other states are deprived of this opportunity to argue, make submissions, make pleadings in their regional language. And the whole concept of Supreme Court, when they passed a resolution, is absolutely misconceived. They say that there has to be a seamless judicial process. Now, this is absolutely a misconception. First of all, High Court is the last court for the state. Supreme Court is not a court of regular appeal. Please mark this. It is not a regular court of appeal. Appeal can be either preferred under the certificate in civil matters from the High Court. So only when the High Court certifies that this is a case fit to be decided by the Supreme Court of India, then only that case can go to Supreme Court. In criminal matters also, usually it is on the certificate, but in death sentences and life imprisonment cases, because of a particular provision in CRPC, and there is a order which was passed by the Supreme Court expanding the jurisdiction of the Supreme Court in criminal side. So by virtue of those provisions, Supreme Court, you can approach Supreme Court in limited criminal cases as a matter of right. So in civil case, you are not entitled to approach as a matter of right. In criminal matters, you are not entitled to approach Supreme Court as a matter of right, barring few cases. As I said, that life imprisonment or death sentences cases. In constitutional matters also, High Court is the last court. Only upon certificate that a particular case involves a very important question of constitutional importance, then only it can go to the Supreme Court of India. We approach the Supreme Court mostly under Article 136, which is not a regular remedy. It is not an appeal. It is a special leave petition. And when only Supreme Court deems it appropriate that this is a case worth granting leave, special leave, then it is registered as appeal. So the whole conception or edifice which is there in the resolution, that there has to be a seamless judiciary and matters are coming from High Court to Supreme Court of India, and therefore if the regional language is permitted, it will create problem to the Supreme Court of India. That is absolutely misconceived, and it is absolutely a myth, because they are not experts. In a particular conference, all the chief justices take a decision which is contrary to the constitution, that cannot prevail in my personal view. So this is how several attempts have been thwarted. Now, when we talk about this, that whether a particular language should be permitted or not in a High Court and Superior Court, we must see global perception on this issue. तो ग्लोबल परसेप्शन क्या है, मैं बोलता हूँ. कनाडा में Canada has 2 official languages, English and French, and both languages have equal status and rights in federal institution, including the courts. The Official Language Act 1988 states that every federal court has duty to ensure that any person giving evidence before it may be heard in the official language of his or her choice. In any proceeding conducted before it, any person who is a party to the proceeding or counsel for such party may use the official language of his or her choice. Any person appearing before it has a right to have available to him or her simultaneous interpretation of the proceedings from one language into another. So Canadian Charter of Rights also guarantees any member of public in Canada has a right to communicate with and receive available services from any head of central office of institution of parliament or government of Canada in English and French. So it is not unknown that there are several countries where more than 2 languages are permitted in superior courts and even in federal court. Now, Switzerland illustration is very interesting. It permits about 4 languages. Switzerland has 4 official languages. One is German, second is French, Italian and Romansh. And each language has equal status and right in the federal institutions, including court. Federal Constitution states that the official languages of the Confederation are German, French, and Italian, and Romansh is also an official language of the Confederation, communicating with the persons who speak Romansh. So, this is the scenario in Switzerland. Now, Belgium. Belgium has three official languages: Dutch, French, German, and each language has equal status and rights in the federal institution, including courts. Now, when there are so many countries, even I have examined even Pakistan court, Supreme Court, where English is a language by default, but Urdu is also permissible. So there are several countries where in superior courts there are more than two languages permitted officially, and it is a choice of the litigant and the lawyer in which language he is most comfortable to express himself. So that kind of facility is permitted, and we are after 77 years of independence. We have such a craze that we will stick to English only, and we give flimsy reasons for not allowing Hindi or regional languages to be used in High Court proceedings. So our endeavor today and our discussion should be, and we should start a movement all over India that permit a regional language to be used in High Court proceedings. We will come to Supreme Court little later. First, let us succeed at the High Court level. And when we succeed at the High Court level, then possibly there is a possibility of having succeeding in Supreme Court in getting introduction of Hindi language as an additional language. Let me again clarify, I am not against English. I am in favor of, I love English language. Huge literature is available in English. So one can give an analogy that our regional language is our house, but English is a window through which you can access to the rich heritage of literature and culture of other countries. So we cannot shut down that language, that window. We must be comfortable in communicating in English. We should learn it, but at the same time, for litigants, their language is a different language, and therefore, in my personal view, we should strive to get in every state regional language to be recognized as an additional language. Now, coming to the several dignitaries have spoken on it. Just 1 minute, and then we will. Prime Minister Narendra Modi had emphasized Indianization of judiciary. He has repeatedly exhorted that regional language should find place in the High Court proceedings. Justice N.V. Ramanna, when he was Chief Justice of India, he has also spoken. He has also recommended use of the regional language in High Court proceedings. Mr. Kiran Rijiju, Law Minister at that time, Amit Shah, Home Minister, everyone has spoken about permitting regional language in High Court proceedings. In Gujarat, the Governor of Gujarat, Mr. Devrat, has also recommended that this should be the language. Now, when they are in this more than two-third majority, who prevents them from making a law? So that is an issue which we will have to focus on when we try to get it politically done. So I thank you, Mr. Keshav Sharma, for giving me this opportunity to share my views on this permitting use of regional languages in the High Court proceedings. So thanks again, and now we can discuss, we can open a question answer session so that we can have dialogue and we can understand the views of others also on this aspect.
Uh, Sir, deeply grateful to you, first of all, for such, how do I say, 360-degree insights. You spoke about all aspects. Frankly, I think the constitutional aspects, the language commission information was just brilliant. All my questions which came to my mind about formation, who are the members, how do they work, what are the operations, everything you covered, sir. Then with respect to the history also, it's just fantastic, sir. It's always a blessing.
Thank
to
you very much.
learn from you. So far we've only done very technical law subjects, topics, but this is the first time that we've done a general topic, and I see how dedicated and motivated you are towards it.
Thank you.
So, in a nutshell, and I think in lighter vein, if I can just say something, I think that probably it's just the fact that it sounds like a comedy of errors. Actually, everyone is in favor, yet I don't know where I could not find out where exactly the problem was in this
No,
situation.
though influential persons like the High Court advocates and Supreme Court advocates who have a say, major say in the policy making, they are against that. They have somehow this fear that if the regional language is permitted, then possibly their practice would suffer. That is somehow that misapprehension in their mind.
So absolutely, I think maybe probably a misapprehension. But so again, I really understand that the kind of experience that you come from with your, how do I say, with a very expansive overview of the legal fraternity, not just for today, but about 30, 35 years of experience that you hold. सो हाँ एक बात सर जो मैं जरूर इसमें
हाँ
बोलना
जी,
चाहूंगा
बोलिए।
कि मैंने सर लास्ट टाइम भी हमारी कोई बात हुई थी, मुझे पता नहीं कहाँ से एक ख्याल याद आया था, उस टाइम पे भी मैंने आपको कहा था गांधी जी की एक बात है जो मुझे याद आती है इस पे.
हम्म,
देयर वाज दिस स्पीच ही वाज गिविंग अंडर ब्रिटिश राज एट आई थिंक इट वाज some university in Uttar Pradesh itself, and with the presence of all of these Britishers and everyone. So he said in that speech that every single Indian suffers a loss of 7 years
हम्म,
simply because of the fact that he has to transition from the native Hindi or whatever their regional language is and learn that extra language, which I see for lawyers also, everyone who's coming from diverse backgrounds. So I've studied in a law college, government law college, law faculty. I had people from across the spectrum. I had people who could not even speak Hindi, who were there and very bright minds. I had people who could only speak Hindi, and I don't know, at least that is what they would say. वो खुद तो वैसे ही बोलना पसंद करते हैं, but everyone has a working knowledge. And so most wonderfully highlighted that it's not about a conflict between languages.
हम्म,
It's only about a desire to express. If I am supposed to represent someone, how will I effectively represent if I cannot express what my thoughts are? I may be comfortable in English. I would do wonders with it. But the eloquence, what you spoke about, so the legacy and every single thing. So how do I say it? This is brilliant, sir, this topic. And so only thing is that I request and I pray that obviously you please, whatever we're there.
no, one aspect is very important which I forgot to state
So,
that in almost all states, the LLB degree or LLB course is permitted to be studied in regional language. Now, all books are available. So, it is not that the language is not sufficient to replace English or it cannot be used in English. We can pursue to study in a regional language up to LLB, even up to LLM. Now, this large number of persons who have studied in Gujarati medium, merely because of the language barrier, they are unable to practice in High Court or Supreme Court of India. So, though on one hand, Bar Council recognizes these degrees as valid degree and they issue practice license on the basis of degrees and study which they have taken in their mother tongue or regional language. On the other hand, merely because the High Court proceedings are to be conducted in English language and Supreme Court proceedings are to be conducted in English language, this large number of persons who have studied in their mother tongue or regional language are deprived. So that's a subtle discrimination which we are not able to grasp it.
so somehow I feel it's like a disability sometimes.
It is a disability.
If I do not have the word to express, sir, in that vein, sir, if I may most humbly, sir, first of all, invite and introduce you, sir, also to Chandar M. Lal, sir, has also joined us. Chandar,
Right.
sir, very warm welcome to you, sir. Sir is a senior advocate practicing at Delhi High Court. He is
Thank
one of
you.
the he's one of the
Namaskar.
most
Namaskar.
amazing, sir. He's one of the most amazing persons I have seen argue in court. So you do not know. I was there in the court, and sir, why I say this is most relevant, Asim sir, right now, is that simply because if sir, there is a flair and there is a manner. How Asim sir, you argue in a very different manner. Chandra sir, how he argues. So I've seen that there was this matter. I think the Delhi five-star hotel's music playing matter, which was there at Delhi High Court.
Hmm.
So I saw you argue in that matter, and on one occasion only I saw, and so I was spellbound. So his language, command over English, command over everything, sir. How he presents in the
I
court
only
of
wish I could have spoken better हिंदी. मैंने
Yes, yes, yes.
हिंदी में 2-3 केसेस राजस्थान में जाके बहस की है मैंने. उसमें प्लीडिंग्स भी प्रिपेयर किए हुए हैं हिंदी में.
अच्छा, बढ़िया है.
बट आई मस्ट से इट वाज अ चैलेंज.
दोनों अच्छी बात है अगर हिंदी में आप कंफर्टेबल है और हिंदी में आपको एक अपॉर्चुनिटी मिलती है बहस करने की तो बहुत बड़ी बात है.
हाँ जी.
हम्म.
No,
so, so
it was an experience. वही है that as our teacher used to say in school कि आप लोग सोचते हैं इंग्लिश में और फिर उसको ट्रांसलेट करते हैं.
So it inhibits your faculty, logical faculty. मेरे हिसाब से बचपन में जो मदर टंग में पढ़ा है मेरे हिसाब से, इट इज़ माई पर्सनल व्यू, आई मे नॉट बी करेक्ट ऑल्सो, बस उसकी फैकल्टी जो डेवलप होती है ही कैन एक्सप्रेस हिमसेल्फ बिकॉज ही हैज स्टडीड इन हिज ओन लैंग्वेज, तो ही कैन
Correct.
एक्सप्रेस इन अ बेटर वे. And because of English is thrust upon him, his vocabulary is limited, his sentence construction ability is limited. Therefore, he is not in a position to express himself properly when it comes to expressing either writing, written, or communication skill.
That's correct because it is a foreign language for us.
Yes, but I am not averse to it. I said in the beginning that it's a wonderful language and one must understand and one must be able to speak and communicate in English. But my difficulty is that why are you not permitting the regional language or Hindi language as an additional language? That is the only thing which we must focus on. We
I
don't
could
want
not
to
agree with
eradicate
you more.
English.
Could not agree with you more. We
the,
must build up the vernacular languages ka level rather than reduce the level of English.
so it's a beautiful thought. Improve the vernacular rather than decrease the level of English. So that's
That's right.
also fantastic insight. Sir, Asim sir, but most humbly, sir, with folded hands, I have this humble request that, sir, it may so also be done that we may have further talks with you on this and obviously all such other relevant topics. And I know, sir, that it's very valuable to you. So if sir, I'm just asking you, what I recall and remember, you resigned from the position of Gujarat High Court Bar Association simply because they did not permit Hindi
Yes,
as a language.
it's a story. Actually, one litigant was there in the Chief Justice's court, Justice Arvind Kumar's court. He wanted to speak in Gujarati and he was insulted. And he said that if you want to speak in Gujarati, I will speak in Kannada. So that incident came to my knowledge, and then I realized that why are we speaking in English only? All the lawyers are from Gujarat. Most of the judges are from Gujarat. So why we are sticking to English only? So there was one occasion where Chief Justice Mr. Vikramnath, Justice Leela Trivedi and Justice Pardiwala were there. So I spoke in Gujarati, gave my speech in Gujarati. And thereafter the movement started and I wrote a letter to governor that please allow Gujarati as an official language. And there was a lots of controversy that you being president, you cannot write a letter. So I withdrew it and I wrote in a personal capacity. Then also the members of the bar objected to it. They said that even if you write in a personal capacity, your position or your letter is imbued by your position or office you are holding, that you are president, and it will have a weightage. And they worried that if the governor accepts my representation, they feared that they will lose substantial practice. So they objected to it, and a situation came where I had to decide whether I should pursue this movement or I should resign from the post. So I decided to resign from the post of president.
So it's a very interesting anecdote, and I'm so grateful to you for sharing that with us. I was just a thing I was just researching, so I came across it. But sir, I'm sir with deepest gratitude, sir. I thank you so much, so kind of you, sir, for sharing
Thank
such wonderful knowledge with us, and at least this hope that there are people who think
If somebody wants to ask any question, we can continue, or we can then.
So actually, so there is this one thing, sir. We have another class with
Okay. That's fine.
Chandal sir, and sir also, sir Asim sir, I will request you that sir Asim that Chandralal sir is, I would say he is, sir, in my humble opinion, sir, and this is because right now I would ideally be introducing you only. So in my humble opinion, sir, he is one of the, if not the best, one of the, I would say the top, whatever numbers could be there, lawyers in intellectual property in India today. So
Oh,
that is
great.
my, I am no one to say anything at all. And I'm like, I have practically whatever least amount of information and knowledge, the more I learn, the more I realize I have nothing at all. But what I have seen, sir, it's just fantastic. So if you can just stay for this session also, sir, it will be really fantastic because, sir, you do mostly criminal law. Lal sir does civil, I think, sir. What I understand, intellectual property is what
Yeah,
I've seen, and the civil I've seen mostly you do.
Yes.
So,
mostly
Asim, sir, if you
civil,
can be
yes.
there, and then, sir, probably some very interesting discussion can also happen towards the end
Yes.
of the
Yes.
session, sir, if that is possible.
Yes, I will stay for some time. I have some preoccupation, but I will definitely stay for some time.
Thank
Let
you.
us begin
So
the
kind of
new
you.
class. New class, no problem.
So kind of you, sir.
Thank you.
So, thank you so much, Asim, sir, for that. And Chandra, sir, it's just, how do I say, the biggest privilege I've had this dream of hosting you at some point of time, which has finally
Chalo,
culminated
good.
today.
Your
Sir,
dream
I
is
mean it. I mean
beautiful.
it, sir. It's going live on YouTube right now, and I mean it, sir. There has to be fans of lawyers. We are fans of uh, people who do anything. They just maintain their fitness. They just do whatever is fancy things, and people respect that for that. But people who are actually putting their lives into making everything happen and work and fine and good for everyone, so people are unaware of them. So, sir, please, I request you to accept my fan note, both
Thank you.
Asim sir and Lal sir. And so again, I'll not get swayed. So, sir, I'm just doing one thing. I'm just ending this live stream right now, and I'm starting another live stream, which will be Lal sir's class. Everything will go as per how it is in the Zoom meeting. Just the live stream will change.
We have to log in
And
again, or?
no, sir, nothing at all. Just the live. I'm just ending the YouTube live stream and
Okay,
I'm
okay,
starting
fine,
the new live stream.
fine.
So